Hello, hello, hello.
And welcome to the Hildebrand Law Firm topic for today.
I'm Kirsten Hildebrand.
And I'm Matt Kaplan.
And today we are going to talk about those in-laws.
Ooh.
Yes, because we get people asking either way. Should we keep our son and our daughter-in-law in the estate or should we not? How do we keep them in or out of the estate is also another question, just depending. So this is a little bit of a sensitive topic because while we love those son-in-law and daughter-in-laws, there's always a sense in which we're not really sure that we want them to be included in the estate plan. So what do you think, Matt?
So, most people come to me and they want to figure out a way to keep the in-laws out of the estate. Not necessarily because they don't like them, but it's more so, I didn't work hard my entire life so that all my stuff could go to my son-in-law, who maybe I like, maybe they don't. It's 50-50. But most of the time it's, how do I make it so that it either goes to my child or it goes to their children, and that the in-law is kind of not in the picture.
I've had a couple where the in-law is so wonderful and so amazing that he or she becomes like a child. And in that case, then there is this desire to have that person treated and the same as if they were a blood child. And I have to tell you, Matt, I get a little nervous about that because I start to think, what if they hang on to the marriage until right after they get their share of the estate and then they split? And so it always does make me a little bit nervous, but we always leave it up to our clients to make that final decision because we aim to please.
Of course.
So let's talk about some ways that we could decide to leave our in-laws in or out of estate plans.
So one of my favorite clauses that I like to draft in all of my documents, whether it be a will, whether it be a trust, is a clause called beneficiary spouse's rights. Especially what's really confusing is states like Wisconsin that are a marital property state, a lot of people think, oh, that's going to go to my daughter, so it's automatically hers and her spouse's, right? No, not necessarily. So I make sure I draft this clause in all of our documents that say just the named beneficiary is the beneficiary. Their spouse, regardless of the state, do not have any rights to the trust property. It's just the individual named. Usually that puts people at ease who are the ones that want to make sure that it doesn't go to the in-law. But a clause like that is vitally important if that's a goal of yours.
Right. I do think that that is a good qualification because presumptively in Wisconsin, it is you're absolutely correct. It is only the child who inherits that portion of the estate that they're receiving. However, because it's a marital property state, there's always that open question.
Yeah.
It's a little bit more fungible, perhaps, in litigation environments as to whether or not there can be a claim made against that share of that child. So I think it is a really good technique to also then include a separate trust for each one of the beneficiaries, because then that helps to protect the beneficial interest that the child is receiving, so that then if there was some sort of litigation that was going on, say for example a divorce, then those assets could be protected inside of that trust that's specifically designated to the child and not to the in-law. So I do think that that is another really important protective measure, especially in a marital property state.
Now, Kirsten, when you mention separate trust for all the kids, let's say I have 4 kids, does that mean when I come to you, I'm going to need to draft 4 different trusts?
Well, no, we do draft 4 separate trusts, but they are inclusive in the main document. So we have sort of what they call a drip down effect, and that is that it goes from the main trust down into the trust for each of the beneficiaries.
Okay, so it's all included in one cohesive document.
Correct.
It's kind of like if you get a club sandwich and you include like turkey, roast beef, maybe corned beef, maybe ham. It's all one sandwich, just 4 different parts.
That's right.
Okay, yeah.
Are you hungry?
Very. And so, going back to that, making sure that all the kids have their own trust. I love that. Making sure that just the named beneficiaries are provided for. Big thing that you need to do that we probably should have mentioned first: name the darn beneficiaries.
Oh,
One
yes.
of the things that people like to do is they say, "I just want to leave it to my children." Unless you're in your 20s, 30s, early 40s, and you plan on having more children, even in that point, I still like to name the beneficiaries, because if the beneficiaries are named, no one can come back and be like, oh, I should be part of children, which is an issue that we see with wills. And so, especially if you're
Yes.
going to get a trust, name the beneficiaries. If you have another kid, come back and get the darn thing amended to include that new kid. But name the individual beneficiaries.
Well, and to get a little bit more interesting relative to that point, we've had, a handful at least of clients who have come in and asked to have their beneficiary children named because they suspect that there might be somebody else out there that could potentially qualify as a child. We've got these genetic tests going on all the time and lots of surprises as a result of that. And so people want to make sure that when wild oats were sown, that there isn't somebody who's going to come back and say, guess what? I too am a child, as that term is undefined
Mm.
in this document. And so if it's undefined, then it's going to be according to Wisconsin statute, which is anyone who is a child of the individual. It doesn't matter whether you're married or not. So I think that is a very important point.
And we've been seeing this happen a lot more and more. I mean, I wasn't around then, so you could probably tell me. The 70s seemed like a really wild time, and people were doing a lot of wild
I was
things.
just a
Well,
little
you weren't around.
kid.
Oh, all
Are you
right.
kidding?
Okay.
Yeah, no,
It's just
I'm not that
because you're
old.
so wise. But I learned that the 70s and 80s were pretty wild, and so people were, running around having kids with each other. And so we've how many times have we seen kids come out of the woodwork?
A lot,
A
a
lot
lot.
more than you expect. And so,
Mm.
making sure that the kids are named, making sure that each kid has their own sub trust built into your own trust, and making sure that you have a specific paragraph that talks about no spouses have rights to the trust money, just the beneficiaries, should help you if that's your goal, is to try to limit that.
And I think one more thing, and that is that inside of each of these trusts that's developed for the children, that there's a paragraph or a provision that addresses what if my child predeceases me. And that is typically where we will see that people may want to have the spouse be the beneficiary because they're thinking, well, if my son passes away and he is married to my beautiful daughter-in-law, I would not want her to be shortchanged. So I would want her to be included if she is married. Now, what's the risk of that? The risk is that she takes the inheritance and then she goes and marries somebody else, and that guy takes all of the money. And now my grandchild is without the benefit of those funds. So that is a risk that you have. But again, in certain cases, people are willing to take that risk on and they're happy to include the in law. However, another way of addressing it would be to simply have it go from child to grandchild, and then necessarily the spouse is going to benefit because if, let's say, there was a decision by the trustee to have $1,000 a month go out towards the grandchild's health, maintenance, welfare, their housing, whatever it might be, well, the other parent of the deceased child is going to be involved and is going to inure the benefit of that. So that's another way of looking at it too.
Interesting. Okay, so it's like the daughter-in-law, son-in-law, they're going to vicariously benefit
Yes,
one way or another. So you don't really have to name them unless you really want to.
that's right. That's right.
I like
That's the
that.
way I kind of see it.
Sure.
So, at any rate, these are the kinds of decisions that you get to make when you come to Hildebrand Law Firm. We talk these things through and make sure that you're entirely comfortable with who it is that you're including and not including in your estate plan. Thanks so much for joining us because we are here for your today and your tomorrow. And we will see you next time.